do you think that the Strata Management Act lacks bite?
No, that depends on how you look at it. So 2nd May 2019, there is a new set of regulations which was introduced. It's called the Strata Management Compounding Offences Regulation 2019. That essentially empowers the COBs, of course after getting the approval of the AGs and all, to issue a compound for the offences that may have been committed from the Act and the regulations. That power is yet to be seen. Also, I've not seen thus far any prosecution was, or rather any any action was taken against the developers, joint management bodies, or the management corporations alike. So, in that sense, maybe the enforcement, they should step up enforcement, because really very much a lot of proprietors continue, or rather the developers continue to run foul of the law. It's for some simple reason that no one is taking action against them. Right? Of course, then you have the tribunal, you know. So if you don't pay, for example, then we can always take you to the tribunal, pay a very minimal 100 ringgit for a residential component, 200 ringgit for a commercial component. Award can be taken, but when it comes to enforcement of the award, it's another issue. Because the amount sometimes is just too small. So it's 5,000, 10,000. You know, when it goes for enforcement, the legal fees may have cost more than that. May cost more than that.
But if you go through the tribunal, obviously you don't need to pay that much. But
yes.
But how do they enforce the tribunal's award?
Well, after taking an award from the tribunal, what you can then do is that, of course, the tribunal will then register it as a court order. Then thereafter, you can execute the award or the court order that is registered in the court. So, in executing these orders, there are of course various methods. The methods are similar to how a civil action is taken against, and then execution arising thereafter. So it includes things like a garnishee, bankruptcy, winding up, writ of seizure and sale.
I see. But if the amount is so small that you cannot warrant, let's say, bankruptcy, for example.
Yes, 50,000 minimum.
So
yes.
How do they pressure the
see, that's the thing where I always tell the GMBs and MCs, look, really whether it makes any commercial sense for you to pursue or not. So some of the GMBs and MCs would do this. They will try to introduce bylaws in trying to recover the legal cost arising from the action taken against the defaulter, for example. Now, the validity of it, I'm not too sure how whether it can be again challenged in the court. But very often, if you try to get that order in the court, that's what we call the solicitor's client's cost. Usually, the court will not grant it to you. The court will only grant you party cost. So ultimately, it still boils down to the GMB and the MC whether they want to pursue full-fledged legal execution methods against these defaulters. So they may cost money.
These defaulters could be playing their card, saying that, knowing that the JMBs might not be willing to take them to court, so they continue being defaulters.
Yes, it is possible. It is possible, especially for those who don't mind losing the right to vote in a general meeting, so they will continue to stay not paying the charges or the sinking fund or contribute to the sinking fund.
Wouldn't they encourage more defaulters if that's the case?
See, not necessary. Some of the JMBs do not, for simple reasons, they do not want to make a precedent, and they wanted to increase the rate of the collection as part of the KPI, especially for the managing agents. So those kind of GMBs and MC would then continue to pursue. All right. Of course, when in the course of pursuing, you also charge them a 10% late payment interest. So that is also some of the ways to deter these defaulters from paying late. So it's a two different spectrum, really depending on the appetite of the GMBs and the MCs whether they want to pursue.
How about the other option of seizing the
movable items
within the unit?
So seizing movable items, of course, you need the COBs to issue the certificate, not the certificate, the form. so far, what I understand is only COB Kajang has done it. So they really moved in and they did the warrant of attachment, seizing the movable items from the parcels. And of course, I think they also face resistance, one of which I think you have also correctly pointed out is some of the items seized may not belong to the parcel owner.
Right.
I think the seizing the items and going for the auction may not be the ideal way to recover the charges also.
So it should be like a last resort.
I am not too sure whether COBs are pursuing this route, but for example, I myself have also tried because I was a chairman for Legalities of Strata, for example, public. We did write to COB KL, but the reply that we got from COB was that they were short-handed. They don't have the manpower to undergo this kind of warrant of attachment.
Yeah. Because as I understand, in Singapore, the maintenance fees is always very, very well collected. A lot of the citizens pay, a lot of owners actually pay out their maintenance fees. Should we be looking at what Singapore has adopted and applied to Malaysian?
All right, I'm not too sure with regards to the provision in Singapore, right? Of course, the biggest difference now, we're talking about Singapore, the Building Common Property and Strata Management Act was this. They have the collective sale provisions, they give discount of 25%, they give discount to 75% for charges for the provisional blocks. But I understand the provisions in terms of collection, they are quite similar in the sense that they still make it an obligation for each purchaser to pay. So these kind of sections in Malaysia, you're looking at the section 12, 25 and 52, if I'm not mistaken, right? It is an offense, all right? There are ways to deter you from not paying. So, for example, a 10% interest rate. There's also a section 60 which says that I can even claim from the successors in title. So it's either you pay now or you continue not to pay one day, or rather if your property gets auctioned off or it's sold to a third party. Essentially, applying those principles and those sections, I can still have the right to claim from you those amount. Yes. So I'm not too sure whether you know how is this going to be applied.
It's a bit different for us, but I do know that in Singapore, one of the final moves they can do is to seize the property itself and put it on the market to cover back the amount owed. But I think that requires a lot of political will for something like that.
Yes, I think so. Because I think if you look at it, I think the more acute problem lies with the low-cost housing than anything else. In terms of the high-rise you see in, for example, downtown KL, this area PG, I think the collection rate is still generally reasonable well. But of course, I think you are right in the sense that there should be more bite to it. The warrant of attachment, for example, I think it's section 34, if I'm not mistaken. The powers are there. All right, you just have to fill in the statutory declaration, write to COB issue the forms, then you can start fixing the dates for you to go in and execute and seizing these properties, movable properties, and then auction it off. But it's always the political will. So whether local authority is prepared to work alongside the JMBs and MC to proceed to undertake this form of attachment.
Is there any movement to change the perception of buyers? A lot of people are concerned when they buy a property. They want the value to go up.
Yes.
So that they can, maybe in the future when they sell it off, earn a nice tidy profit from it, or at least use it to upgrade their property. So I don't really see a lot of movement in educating especially the lower income earners to ensure that management fees is paid so that it will elevate the value of their property. Do you think we should push forward for this kind of direction to educate the
Yes, I think the local authorities through the COBs are doing their part in training, or rather providing free seminars. Some of the seminars are even free to the joint management body, joint management committee members, elected members, and also to the management corporation elected members. I remember even one I attended, they even give you a certain amount of allowance if you attend those kind of seminars. So that is of course good, you know, to bring awareness to the public at large, increase their knowledge of what they need to do and what they need not to do. In fact, it's more than just to pay charges. There are a lot more things than just to pay charges. For example, one of which they also they have the duty to inform if there's a sub-sale, for example. There's a change of ownership, you know, they must also inform. So, so of course, I'm also involved, as I shared with you, Joseph, that some of the organizers, in fact, invite me to talks like this, by giving talks like this. The main objectives of these organizers, whenever they speak to me, it's also, again, to bring awareness to three different categories of people at large. One is, of course, the developers. They themselves must set their foot, you know, down and say, look, this is what has to be done because of this new statutory regime. Of course, two, the joint management bodies and MCs. And three, we can also see an increased trend of those elected members or proprietors at large wanting to know what are the rights and wanting to know what is correct and what's wrong and how do you construe certain sections. They also do attend this kind of seminars now.
I understand you have a seminar coming up on September 5th.
Yes, I think it's 5th of September. It's organized by Legal Logic. Legal Logic has been inviting me, in fact, and a few other speakers to speak on strata management related issues. What I do usually being invited to speak are very much strata management related issues. So things like, for example, interfloor leakages, multiple rates, uniform rates, provisional blocks, whether to pay when it's not even erected. It also comprises issues like Airbnb issues, short lease items, whether can you regulate, whether should you allow or should you not allow. Also on the 5th of September, that is so. I think I will be speaking on these issues.
The venue will be at?
The venue will be at
Hotel Istana.
Hotel Istana, yes, that's right. Hotel Istana, I can't remember. Yeah, Hotel Istana, yes.
Should be interesting. It's going to be a whole day event.
It's going to be a whole day event. Of course, this is not the first time I've been speaking with Legal Logic. I've spoken to them. They have invited me to a few sessions. And the coming one is Hotel Istana. I've also spoken to them in the Penang talk and a few more other venues. The last talk we had was, yes, also in the Hotel Istana, and we had also a very good mixture. Of course, we also have some of the commissioner of buildings, officers. They also do attend, and a mixture of developers, property managers also, to have a basic understanding, and at least they will move towards, from a very basic surface kind of topics, moving into a more complicated in construing. For example, if you have 5 parcels, I have arrears on 3 parcels, can I still exercise my vote on these 2 parcels? You know, it's kind of things which is still very grey in the existing legislations.
I see. So for this seminar, these 3 groups of people that you're targeting, what are you hoping for them to take away from the seminar?
Well, I think really every time I speak to different organizers, so I don't speak to, every time I was invited to speak, I hope when the proprietors at large, or rather any of the participants who came to the talks, will go back with at least with some basic understanding of how these statutory piece of legislation was drafted in 4 different periods, for example. You know, developers management period, preliminary management period, joint management body, and how the management corporation come into picture. And what are the obligations that they have? What are the responsibilities? You know, what are the powers they have? They cannot exceed in doing some acts which they don't have power with. Otherwise, it's going to be an ultra virus. So I also see a lot of JMBs, MCs. You know, they're doing things which is completely out of scope completely beyond the powers. That's scary, and of course then it results in different suits being filed against each other, or different camps between the same JMCs. So that's something which I really wanted to introduce, and at least tell them, look, these are the basic understanding. If you really want to know what their responsibilities, please look at the sections, and these should be construed in this manner because there are certain restrictions which needs to be read together. So these are things I just wanted to introduce them basic understanding, not by just construing one sentence in one section and then trying to apply that one sentence to the whole context of it.
I see. You mentioned that there were cases where there was lawsuit from one management to the other. How far-reaching is that? I mean, if the one management committee runs afoul over something, and then it's only discovered at a longer time period, is there a limit to the time period?
In filing a suit, you mean?
Yes.
So there is a section which talks about limitation period not applying. Limitation period doesn't apply to the tribunal for strata management issues. But what you said is if you discover some form of irregularities, for example, that again depends on what other irregularities are, and also the point where you discover. From that point, the limitation period should still apply. Depending again on what kind of issues with that. So for example, if you said that a parcel owner has not been paying for the past 12 years, limitation period doesn't apply because there's a court of appeal case which says that. But if you're talking about within 6 years you've discovered issue with pilferage, for example, misappropriation of monies, criminal aside, being a criminal case aside, you should recover within a certain number of years.
What is the number of years?
I would still say that the 6 years is still the limitation period that you should be looking into.
So whoever takes over should really look into the books, basically.
Yes.
Okay, thank you very much for your time.
No problem.
It has been entertaining as well as informative.
Yes.
And hope that your seminar will go on well.
Oh, thank you. I also hope all the participants, again, I'm just sharing the same thing. If you think you have an interest in this area, whether you're a parcel owner alone, you're an individual parcel owner, managing agents, developer, joint management bodies and management corporation, please attend. Just contact the organizer, and then I'll see them on the day.
All right. Thank you.
Thank you. Thank you. Thank you. Thank you. Thank you.